Friedberg et al. Versus O'Doyle rules. Okay, we're ready.
Good morning, Your Honors. May I proceed?
Yes, go right ahead.
My name is Todd Hepker. I represent the appellants James A. Friedberg and Samuel Israel. We're the co-trustees of the Irvin and Suzanne Bard Family Trust, which I'll call the trust. I'd like to reserve 5 minutes of my time, Your Honors, for rebuttal. The trust seeks to reverse the trial court summary judgment that was entered in favor of O'Doyle in this case, which involves a right of first refusal given to SunTrust Bank in its lease with the trust. Section 46 of the lease gives SunTrust that right of first refusal to purchase the property if the trust receives an offer to purchase the property from a third party. On February 8th, 2018, the trust and O'Doyle entered into an agreement to purchase the property. The purchase price was $1.85 million. Under Section 10.2 of that purchase agreement, the trust obligation to sell the property to O'Doyle is expressly contingent and conditioned upon SunTrust's waiver of its right of first refusal under Section 46 of the lease, or its failure to exercise its right of first refusal within the exercise period specified in that lease. The trust gave SunTrust notice of the contract between O'Doyle and the trust, timely did that, and SunTrust waived its right of first refusal with respect to that contract with that
I have a question.
price.
Could I interrupt? I have a question about
Yes, Your Honor.
I have a question about the trial court's rationale, which I perceive, at least is what I saw on the record, to be slightly different than what the appellees are arguing. The trial court seemed to acknowledge that the sales contract addendum was materially different, and acknowledged that, but made the conclusion that notwithstanding O'Doyle's rights, but it didn't have any. Well, I'll stop there. Would you agree?
Yeah, I don't know what theory of O'Doyle's theories the trial court accepted, Your Honor. I've mentioned 3 different theories, I think, in the brief, in our briefing. I will argue this. I argued it in the brief. The trust gets to decide whether the new offer, which I'll get to in a minute, the new offer, which is specified in the addendum, after SunTrust waived its right of first refusal with respect to the $1.85 million contract, O'Doyle renegotiated the purchase price with the trust, reduced the purchase price by $50,000. The trust then felt obligated under the right of first refusal to send another notice to SunTrust to protect both the trust and O'Doyle, because if SunTrust had found out that the trust had sold the property to O'Doyle with a different purchase price, the SunTrust could have sued both the trust and O'Doyle. So the trust sent a second notice to SunTrust, who then timely accepted and exercised their right of first refusal. And the trial court apparently thought that was not correct. I'm not sure, again, under what theory that O'Doyle asserted that summary judgment could have been granted. So when SunTrust exercised its right of first refusal for the $1.8 million purchase price, the trust then sent notice of that to O'Doyle, terminated the purchase agreement with O'Doyle because of the express contingency in Section 10.2 of the purchase agreement. Then the trust and SunTrust entered into a contract on June 14th, 2018, but that contract never closed because O'Doyle filed the instant lawsuit seeking specific performance in count one, damages for the difference between the agreed purchase price and the fair market value of the property in count two, and declaratory and injunctive relief in count three. They also recorded a les pendens to keep the property from being sold to SunTrust.
What was the trust performance obligation under the sales contract addendum expressly contingent on SunTrust waiver?
Yes, Jess. No other parts of the purchase agreement were changed in the addendum except for the purchase price being changed from 1.85 to 1.8 and a different closing date, an accelerated closing date of March 14th, 2018. And SunTrust had not exercised, because it didn't have to, it had not exercised its right of first refusal on March 14th, 2018. So our position, as we've specified in our papers, is that O'Doyle simply didn't sustain its heavy burden to show that there were no genuine issues of material fact, or that it was entitled to a judgment on those three counts as a matter of law. In fact, O'Doyle did not seek summary judgment on count three, and O'Doyle did not seek damages incidents to specific performance in count two, which the court also awarded in its partial final judgment. And
go to the
go ahead, Your Honor.
specific requirements for specific performance. Now, I just wanted to know your perception of how the burden is to operate there. Now, if the complaining party, if the plaintiff avers that it is ready, willing, and able, says, "Hey, I got, the loan officers gave me the green light," whatever. Does the burden shift then to the defendant? And
well, in this case, Your Honor, O'Doyle specifically pled in its complaint that it was ready, willing, and able to.
And keep in mind, we're at summary judgment, right? So if an affidavit saying, "Hey, I got the money, I'm ready to give it to you," if that's unrebutted, is that sufficient?
Well, it was not. It was not unrebutted. It was not unrebutted in this case. We denied that specific allegation. It's paragraph 32 of the complaint, and we asserted in our affirmative defenses that O'Doyle had not complied with the purchase agreement. We also pointed out at the hearing and in our opposition papers that even though there was a self-serving conclusory statement in the only proof that O'Doyle submitted in support of its summary judgment motion, that it was ready, willing, and able to comply, I took Mr. Neary's deposition. He's the sole member of O'Doyle. He admitted that O'Doyle did not have a bank account. He would not divulge the source of the funds that O'Doyle was going to use to close. And he essentially wouldn't say how O'Doyle was ready, willing, and able to close. So that created a genuine issue of material fact right there. That is a question of fact, because that is the threshold inquiry that the court must make in any specific performance case. Was that plaintiff ready, willing, and able to close? I also point out in our brief, Your Honor, because O'Doyle also did not comply with the purchase agreement because it was required to place a second $50,000 supplemental deposit with the escrow agent 2 days after the expiration of the due diligence period. It's undisputed that they did not do that. So in our view, as we argued in our papers, the plaintiff did not prove by clear and convincing evidence, which is the standard.
Well, can I stop you there? What wasn't the argument, O'Doyle's argument, that requirement had been obviated pursuant to the expedited closing date?
Well, O'Doyle makes that argument in its answer brief, but there's no proof of any express waiver by the trust. And once again, that would be a question of fact.
That's not the way your client defended, and they didn't say, "Oh well, you you repudiated or anticipatorily breached the sales contract that by not providing the second 50 grand. It said we have no obligation to sell to you anymore because there was a proper exercise. So unless you're saying that goes toward the ready, willingness, and ability.
It does, and our affirmative defense.
Was that how it was argued?
Yes, and well, the judge didn't really get into that argument at all during the summary judgment hearing, but our pleadings and our affirmative defenses, one of our affirmative defenses was that the O'Doyle breached the purchase agreement, and we were excused.
How? What was the rationale? Breached it by doing what?
But by not complying with it. We did not specify in the affirmative defense.
Just a general defense. Oh, you didn't, just the boilerplate. You breached.
You breached it.
So it was never argued that it was the second $50,000 payment.
That's correct. That's argued in our opposition papers.
So the other, you're actually go on. Sorry.
So this court, I'm sure, is well aware of the very heavy burden that O'Doyle had to obtain summary judgment. It had to prove that the complete absence of any genuine issue of material fact, and it was entitled to a judgment of law. We assert that the trial court almost shifted the burden without requiring O'Doyle to prove the absence of any material fact by
what are the material facts? What are the material facts that
fact issues? The material
fact issues that preclude summary judgment?
Well, based on the argument that was made by O'Doyle, whether that $50,000 reduction in the purchase price was fairly comparable to the 1.8.
So that is a fact issue. So in other words, the trial court couldn't rely on by memory or by research the wealth of cases that say if you change the purchase price, that's a material change that renders the exercise of the right of first refusal invalid.
Well,
I know there's specific. You're saying there's specific language that said fairly. Use the word fairly.
Comparable. Yes, the court had to decide whether that $50,000 was material, and we obviously have asserted that it was. In fact, SunTrust believed it was material because the record reveals that SunTrust didn't exercise its right of first refusal when the purchase price was 1.85, but then exercised its right of first refusal when the purchase price was 1.8. And Mr. Pommet, SunTrust real estate manager, testified in deposition that $50,000 made the difference, and that $1.8 million purchase price, as opposed to the $1.85 million purchase price, met its threshold. So the $50,000 was certainly material to the trust, and SunTrust admitted under oath that it was material for them. So I don't understand how the trial court could have determined, if that's what its theory was, if that's what its conclusion was, that there was not a material change which allowed and permitted the trust to send the second notice. Because O'Doyle's whole case turns on that the trust shouldn't have given SunTrust the second notice of the reduced purchase price. And because it shouldn't, then SunTrust would not have had the opportunity to exercise its right of refusal. And then there would not be this failure of the contingency. So that's really the whole case turned on that, at least if you believe that the court accepted that argument.
So, Mr. Hupker, basically, to reach summary judgment, the trial court had to assume that the $50,000 was de minimis and there shouldn't have been any additional notice needed to be given. Is that
that's
summary
correct.
of your argument?
That's what I'm arguing, that the trial court made that determination and shouldn't. I think it's contrary to, in my view, common sense.
Well, obviously.
Isn't it also
obviously-
contrary then-
obviously There was consideration for that, right? It was all, what, wasn't the $50,000 reduction, it was connected to a new closing date?
Yeah, well, we assert that
So
it
what-
wasn't connected at all to the closing date. We didn't ask for an expedited closing date, and we could have
Well-
waived it if we wanted. Why would we take less money, less money just to get it quicker?
Well,
It actually
somehow,
made no
though,
sense.
somehow the addendum was negotiated.
It was negotiated because O'Doyle essentially said right before its due diligence period expired, we're not purchasing the property. We're not going to purchase the property unless you agree to a reduced purchase price. That's how it went. It had
So
nothing to
then
do.
your client's interpretation then under its lease agreement with SunTrust is this was essentially an offer to purchase which you were prepared to accept. I mean, that's how the right of first refusal is.
That is
and-
correct.
This was basically a new offer to purchase which you were prepared to accept.
Exactly. And if you look at SunTrust's waiver letter with respect to the first contract, the 1.85, SunTrust was very careful when it responded and waived the right of first refusal.
So it wasn't raising the right of for future offers, right?
Yes,
So,
it said
Mike-
nothing. I'm sorry, Your Honor.
Oh, I'm sorry. Yeah. I'm just
They weren't
making-
giving up the right of first refusal. They just weren't taking that deal.
Correct. Nothing contained herein shall be deemed or construed to waive or diminish SunTrust's right of first refusal to purchase the property with regards to any other offers. So the trust felt it absolutely had no choice
Right.
but to give that second notice. And once that
Mr.
second
Hector,
notice
you are
was
into
given-
your 5-minute rebuttal time. So proceed as you please.
Okay, I've already talked about the specific performance issue that O'Doyle did not prove that it was ready, willing, and able to comply without any doubt based on Mr. Neary's testimony alone. And I will reserve the rest of my time for rebuttal, Your Honors.
Yeah, you got right at 5 minutes. So,
Thank you.
okay, Mr. Koenig.
Thank you. May it please the court, my name is Eric Koenig. I am from Trentham Law and I represent O'Doyle Rules LLC. Respectfully request this court uphold the trial court's summary judgment in this matter. I know Mr. Hopker ran through a variety of facts in this case, but I believe there are 3 facts omitted that are fairly important for this court to consider. First is that second notice to SunTrust that they are calling the second right of first refusal failed to contain the expedited closing date, which formed the basis of the $50,000 credit.
Let me ask you about that. So let's say that was, so you're saying that didn't match essentially because it didn't, the SunTrust didn't accede to the closing date. But if O'Doyle Rules waived the closing date, then essentially O'Doyle Rules altered its own second offer by omitting the expedited closing date, which means that SunTrust then did match by acceding to the only difference, which was the $50,000.
Not necessarily, Your Honor, that the addendum was the further negotiation of the original offer that is actually permitted under the lease agreement that the parties can continue to negotiate if they wish. And this was about 3% or so of the purchase price. The idea is you get your money a lot quicker if we're willing to reduce the cost, and that unbeknownst.
Mr. Koenig, if that were
go ahead.
If that were the case, why not simply put a hold harmless in there? Your client take the responsibility for it if you don't think that they needed to notice them.
Well, they didn't think they needed to notice them, Your Honor.
I know they didn't think they needed to notice them, but because you didn't think 50,000 was something that qualified for a new notice?
Well, so for 2 reasons, Your Honor. First is that it was a de minimis change and therefore non-material. But second,
It was material enough that your client felt that the difference between 1.85 and 1.8 would allow them to do the purchase. Correct? I mean, your client wanted to make that change. So but you're arguing it's de minimis. If they really wanted the building, they could have just went forward with it and said, we're ready to close now.
Well, and certainly there is that there is no evidence in the record that my clients outright refused to close absent the $50,000 reduction in the expedited closing.
But they made another offer. They said, we don't want to pay the 50,000. We'd rather pay less.
Was that the parties came together in the addendum agreeing after reaching the original deal that they would negotiate a quicker closing in return for a credit, which would be that second deposit.
That sounds like another offer.
It was not another offer. That this is an additional movement on the original deal reached, and O'Doyle wanted to close quickly. Obviously, the trust wanted to close quickly, and the parties entered into the addendum that allowed them to close quickly. And
So you don't think it's another offer? Let me ask you this. I asked opposing counsel. There's just an order without explanation, but there's explanation for the trial court's rationale on the record on page 1151 to 1153. And the way I read it, the trial court seems to think that it was a materially different term, and that it was essentially it was another offer, but that nonetheless, because there had already been a first right of refusal, and then O'Doyle entered into this sales contract, that it did not have any effect on the right to the performance of the sales contract. Now, that's a compound question. Do you agree that the trial court thought that it was material? And second, the trial court's rationale that to nonetheless rule in favor of O'Doyle is flawed because the sales contract addendum made the trust performance obligation under the sales contract expressly contingent on the waiver of a right of first refusal.
I respectfully disagree with the idea that the trial court specifically found this to be a materially new offer. That the discussion was that SunTrust may have believed this was a material new offer, but it appears that the judge was speaking in hypothetical, that even assuming this is a new material offer.
He said the court said the fact that the trust elected to enter into an addendum with the plaintiff, which clearly would constitute a breach of the right of first refusal, the paragraph 46 of the bill to suit lease, which, but he said is no consequence as it relates to the mutuality of obligations between the plaintiff and the defendant relating to the addendum that was already signed and controlled the obligations between those two parties.
Correct.
Wouldn't you say you're saying that that's not a ruling, or at least a insight into the mind of the judge? The judge said that yes, this is another offer for which the trust would be liable essentially to SunTrust under the right of first refusal contract it had with SunTrust.
And the reason I respectfully disagree, Your Honor, is being there and hearing the judge's inflection in that context, as we were discussing, that the purported second right of first refusal did not contain all the material terms.
Mr. Koenig, let's go back to the time when the new agreement had been reached for whether it's a de minimis or a new offer, whatever it is, and SunTrust was now put on notice. Why did not, if your client felt there was absolutely no reason and no requirement to go forward, why did they not raise this issue right away and say, I'm sorry, we're ready to go to closing and you're going back to SunTrust and there's no reason to do that? They could have put them on notice, like I said, could have offered to hold harmless and said, let's just get this over with. They clearly aren't interested. There's not been a change. None of that happened.
Two answers to that question, Your Honor. First is that Mr. Neary testified in his deposition that there were those phone call communications. There was the confusion as to why the second notice was given. And more importantly, to answer the question more conclusively, is that O'Doyle ended up working with SunTrust, and SunTrust ultimately waived any purported the second right of first refusal. That
was after the fact.
Correct. The idea is it was raised originally, it was dealt with and discussed, And as I understand, we're attempting to find a business resolution to push this forward because SunTrust at one point said, look, we will walk away from this deal.
Let me ask you this, and I don't want to speak for Judge Stargell, but I don't know if that answers his question. I think he's talking about the fact, he can correct me if I'm wrong, that instead of at the where the rubber was about to meet the road, the closing date was coming up. Instead of saying, you don't need to talk, you don't need to notice SunTrust. Let's get this deal done. Why does the documentary evidence suggest that O'Doyle Rules said, oh yeah, let's give it some time. Let's blow past the supposedly negotiated expedited closing date and give SunTrust its 30 days?
As far as I could tell, Your Honor, and based on the record evidence before Your Honor, there just aren't a lot of documents related to that, but there were many conversations.
There was what about the emails?
The same. It's my understanding that these folks did not, at least the record as this court has it, there weren't a lot of emails. That these
let me ask you this. Are there not emails for counsel from O'Doyle's counsel conveying to the trust, I hear you, we're willing to continue the supposedly negotiated closing date so that to give SunTrust more time to decide whether to exercise its right? Are there not those emails in the summary judgment record?
Correct. There were emails that the parties were attempting to resolve things on business dealings, but the fact that the parties were trying to work things out don't constitute.
No, we're not talking about then, not down the road. At that very time, there was email communications, were there not?
Yes, Your Honor. That there were those emails that ultimately ended up in the agreement with SunTrust to waive that second right of first refusal provided.
But that's way down the road when SunTrust, I mean, at that point, they don't want to be in litigation. They don't want to be involved with it, whatever. They say, fine, you all work it out. But when the notice was first given, were there not emails that basically said, okay, I can't remember the exact, I think it was Mr. Flynn. There's some emails that went back and forth. Is that not correct?
That's correct, Your Honor. There were emails in the attempt to resolve the issues.
All right, let me ask. So I think what I think of Judge Starr's question is that it shows that at the time, the O'Doyle considered this to be potentially, counsel for O'Doyle considered this to have been a material change, constituting a new offer for which a right of first refusal was required. But I want to go further and say, do those emails, what was not both in the emails, communications, and the fact that they blew past the closing date, was it not the case that the sales contract addendum, that offer was altered to eliminate the expedited closing date? And if so, didn't SunTrust then match the offer by offering the $50,000 reduced price?
It was not, Your Honor. That at no time had the addendum been rewritten or revisited. And I do understand the questions that there had been some time that had gone by and went past the expedited closing date. And at that point, the attorneys are talking, there is threats of litigation. And again, it's the idea of the parties were attempting to resolve the issue and ultimately led to the resolution of SunTrust waiving that second right of first refusal. So even if there was a second offer that was not right, even if Doyle ultimately waived this expedited closing, it came to the point that, as we argued in the trial court summary judgment, at one point the trust needs to sell something. Either they need to sell to SunTrust under that second right of first refusal, and SunTrust waived that right and said, you know what, it's a late waiver, but we waive it, or it needs to go to O'Doyle, and either or. And SunTrust had given it up, and that's why the parties had worked toward trying to get this resolved rather than take the hardline position in litigation.
Hey, Mr. Koenig, let me ask you this hypothetical, so to speak. Okay, it had gone forward and on the 1.8, and you closed, and they had taken your position that there was no need to notice them on this new amount, whether you consider it an offer or whatever it was. There's a new amount that closed for 1.8. Is it your position that SunTrust would have no right to then sue on their right of first refusal?
It is for two reasons, Your Honor. First, that a 2.7% difference in the purchase price would likely be deemed non-material by a trier of fact. And second,
Well, isn't that the whole issue here on a summary judgment, whether that should go back for them to decide if it's a material issue, if 2.7%, $50,000 is material or is not material?
Well, that's certainly the point Mr. Hooker has been arguing, and that is an issue that the trial court mentioned. I don't believe the trial court had an express finding whether there was whether this additional offer was in fact material or otherwise. But the second issue is the expedited closing, which was only, I think it was about a week and a half from the date of the addendum execution, that the second right of first refusal, which requires 30 days, would have been impossible to provide. That it would defeat the purpose of entering into that addendum for the expedited closing, that SunTrust couldn't respond within the 30 days. And that's why it was.
Let's take that for a second. So in other words, they made an offer that was contingent on the right of first refusal that permits the holder to take 30 days to decide. So if we decide anything's not material, perhaps it's the closing date, which was impossible given that the offer was contingent, that the right of O'Doyle was to get the trust performance on its sales contract was contingent on the right of first refusal, which gave 30 days. So isn't that pros a problem, that O'Doyle's contract rights were expressly subject to the SunTrust's right of first refusal rights?
Not in this circumstance, Your Honor, as there had already been a deal reached and the parties at that point merely negotiated a quicker closing in return for credit at the end. That this was not a second offer, this was not a second deal. These were parties that had reached an agreement and then discussed and negotiated a faster closing in return for the credit during the closing.
Well, but we were talking about something different. I mean, we're going back to your argument that it's not a second offer. But if it was a second offer, can a proposed third-party seller and the owner, property owner, in a contract that is expressly subject to the right of first refusal, in other words, the putative sale or the can they override? Can they essentially, on behalf of the holder of the right, waive their right to 30 days?
That's a loaded question, Your Honor. It's a tough one to state from a hypothetical standpoint.
It's a bit circuitous, but that's the situation we find ourselves in. But the problem is not the problem. The fact that went away, after O'Doyle through counsel said, don't worry about the closing date. And B, they blew the deadline. The closing date came and went.
And certainly based on the questions being asked by the panel and revisiting the issue, I'll defer not only to my responses so far that this was not a new offer, and to the extent it was de minimis. And at the end of the day, SunTrust waived that second right of first refusal. Whether we go down the tipsy coachman, whether we go down any other basis, that the trust was obligated to sell the property. Who was the trust going to sell the property to?
So let me ask you this. So 14 months later, SunTrust says I don't know why they entered into the settlement. We're sick of litigating. Is a relatively plausible theory. And but even if we conclude that it had a right of first refusal and summary judgment was improperly granted in favor of O'Doyle, because there's a settlement agreement 14 months later, you still get at the subsequent damages hearing all the rents that supposedly you're owed under a summary judgment that shouldn't have been entered in your favor. I mean, I'm not saying that's what we're going to decide it, but that's what it sounds like you're saying, that based on this subsequent settlement agreement, that leaves this court without any ability to correct the improperly entered summary judgment, which would lead to, hey, you get a bunch of rents because now that you have summary judgment in your favor, you get to go to damages and get all your damages.
Well, if in our circumstance, SunTrust agreeing to the settlement agreement and waiving all rights that it would have to purchase this property and therefore recover the rents and otherwise, then in a sense, Your Honor, yes, that if a judgment is entered for these back rents.
So the trust thought it was honoring its right of first refusal. If this court decides that it should have honored its first refusal, then the subsequent agreements, tell me if I'm not following this right, a subsequent agreement between the holder of the right of first refusal and the third party offer now means that the trust has to disgorge all of its rents to O'Doyle?
Yes, the same idea.
Even if we decide that it was doing the right thing, meaning what it was contractually obligated to do by honoring the right of first refusal, now it has to disgorge all of these rents that it got from SunTrust because subsequently SunTrust settled with O'Doyle?
Well, that's what the agreement was, Your Honor, that SunTrust, because again, the trust.
Wasn't that the agreement? Is there a contractually, was there a right for a remedy for damages? Because I thought I saw that the specific performance was the remedy. Was there a contractual remedy for damages?
There is not, and we sought damages incident to specific performance.
Now that Judge Sturgill made that astute observation, I want to qualify my question by saying I was not prematurely deciding that issue. I was just saying that's what you're seeking. I'm not saying that those damages are not foreclosed by the express limitation of remedies, but that's what you're seeking. You're seeking to get all these rents back from the trust based on a subsequent 14-month later settlement agreement with the holder of the right of first refusal.
As that it was either the property should not have been subject to a second right of first refusal and therefore we are entitled to the back rents, or SunTrust ultimately waived its right to that second right of first refusal. And again, it is not based upon anyone acting as a bad guy here. It's that the trust was obligated to sell the property to one of us, and the trust ultimately determined not to sell it to either of us. And if SunTrust doesn't want the property and has waived its rights, then O'Doyle is obligated to purchase the property. And again, it will be based on the judge's determination as to whether O'Doyle would be able to cover all of those rents, or perhaps the rents up to the time of the settlement agreement. That would be a question.
And Mr. Koenig, you're at your 20 minutes.
Thank you.
Thank you. Mr. Hepker?
Yes, thank you, Your Honors. I've got a number of points to respond to. I think that, and I pointed this out in our brief, I think that O'Doyle and the trial court, if you believe the trial court ruled on this basis, which is difficult to understand how the trial court got to where it got, I think they have it backwards. The second purchase agreement is subject to the right of first refusal, not the other way around. I believe that the trial court, and again, I'm speculating, that the trial court believed that somehow the second purchase agreement trumped the right of first refusal. And I think that's backwards with all due respect. With respect to the issue about the negotiations where there was a reduction of the purchase price in 1.8 and the different closing date that was set, Mr. Friedberg's sworn affidavit in opposition discusses that in detail. He didn't make, O'Doyle made the offer. O'Doyle renegotiated the deal at the end of the due diligence period. Why would my client want to take $50,000 less unless it was forced down his throat to kind of be pejorative there? We didn't, and Mr. Friedberg's affidavit completely disagrees with the notion that that there was this quid pro quo. There was a quick closing date where the trust got $50,000 less. The trust would have been completely content to wait and gotten $50,000 extra. With respect to and I think Your Honor.
Let me ask you quickly right there. Let's say that, leaving aside that the new closing date was blown and there was according to the emails, it sounds like it was a possibility that was waived by O'Doyle. Now let's say that my understanding is that that SunTrust was not, that portion of the new offer, to be conclusory, was not communicated to SunTrust.
No.
Now, if that was the case, and we leave aside the supposed waiver on O'Doyle's part of the new closing date, who would that be on? Wouldn't that be on the trust for not? In other words, if that's the trust liability, you failed to properly convey the entirety of the new offer, and therefore O'Doyle's rights are still in place because the SunTrust was never even given an opportunity to actually effectively exercise its right.
It actually did, in Your Honor. If you look in our brief in the record, Mr. Friedberg has testified in his affidavit that he told SunTrust about the March 14th, 2018 closing date. And if Mr. Pommet in his deposition swore under oath that he was notified of that closing date. And
now, am I correct to say that O'Doyle has contradicted that? Am I correct to say that?
I don't know how they could contradict Mr. Friedberg's sworn testimony or Mr. Pommet's sworn testimony that he was notified, because Mr. Pommet also testified that on behalf of SunTrust, remember, he's a real estate manager, he viewed any accelerated closing date as a violation of their right to either exercise or not exercise within that 30-day period. And going on with this waiver question or issue, Your Honor, we just extensively discussed in our briefing what Mr. Fink's emails say. He had no problem with delaying the closing until SunTrust decided whether or not to exercise its right of first refusal. The emails are in the record. I could cite them for you.
I've been discussing them, so I think.
Yeah, they're discussed on page 8 of my initial brief. One point that needs to be brought up, I believe, is that, and I make this point in our brief, that I don't believe that O'Doyle had any standing, because it's not a party to the lease. It's not a third-party beneficiary.
Yeah, no, you say they don't have a day of standing, but he's not suing. He's not suing on the right of first refusal. He's not attacking it. He's saying that he's suing on his sales contract and saying, and the argument is that the right of first refusal does not excuse the trust's performance obligation.
Yes, but
why doesn't he have standing to sue on the sales contract to which he's a party?
He certainly has standing to sue on the sales contract. My argument is that he doesn't have standing to question what SunTrust or the trust did with respect to the right of first refusal. And
now, if that was the case, that deprived someone who had a right under sales contract of standing, then the defendant, the other party to the sales contract could just say, hey, you know what? There's an our right of first refusal, and they say, well, you can't challenge that. A, there really was a right of first refusal, and B, that there really was an exercise, so you lose.
My argument is when you're talking about a question in this unique set of facts where O'Doyle's now trying to argue that it was not material, was not fairly comparable, I don't think they can step into the shoes and second guess what SunTrust or the trust did. And I cited in our reply brief the acquisition trust case, which I know Your Honor, Judge Atkinson, you were on the panel and dissented, where this court ruled that prospective purchasers,
as you can imagine,
have prospective purchasers. I think the upshot of that ruling was that prospective purchasers don't have the standing to challenge the propriety of performance under contracts to which they weren't a party.
Let me ask you that prospective purchasers, not
okay. Make this the last question because you guys have used up Mr. Hector's rebuttal time.
Thank you.
Now, I understand the facts of that case, but it included a completed sales contract. But is he really a prospective? I mean, he's a prospective purchaser, but he has rights under the contract, and the defense is that this ROFR excuses performance obligations. Why doesn't he have standing to attack that defense?
I don't believe that he can go in and argue what is or not fairly comparable. And once that right of first refusal was properly exercised by SunTrust, as acquisition trust holds, they have no other, O'Doyle had no other rights to purchase that property. I would respectfully ask that this court reverse the summary judgment that was rendered, the partial final judgment that was rendered in favor of O'Doyle by the trial court.
Okay. Thank you both very much. Interesting
Thank you.
case. To leave, you click the leave button in the lower right-hand corner of your Zoom screen.